Hello, I'm attorney Gary Finklea from the Finklea Law Firm in Florence, South Carolina. Yesterday I had the opportunity to depose a lawyer who prepared a will for a person, and that will is now being challenged in court. Today I would like to speak with you regarding the capacity required for a person to make a will. Generally, we look to the South Carolina Code for our definitions, and in the South Carolina Code the statute specifically states that a person who is not a minor and is of sound mind may make a will. Now, whether a person is of sound mind is the big question in these cases, and the statute, of course, does not define whether or not or what the standard is as to a person is of sound mind. Therefore, we need to look to the cases decided under that statute. Very early on, our Supreme Court had the opportunity to address that issue in a case of Matheson v. Matheson. It was decided by the Supreme Court in 1923 and is filed at 125 S.C. 165. That's our Code of Laws. Actually, some of the lawyers in that case were from Florence and then in Bennettsville. In that particular case, the court outlined a three-pronged standard to determine whether or not a person had the requisite mental capacity or sound mind to execute the will. And those three requirements is that the testator, that's the person who's making the will, first must know the nature and extent of his property. In other words, what does he own? Second, he must know the natural objects of his bounty. In other words, he needs to know who his family are. Third, that he is in fact making a will. All of these elements are important so that the testator can make an orderly and proper distribution of his property. Generally, it is stated that the mental capacity necessary to execute a will can be less than the mental capacity necessary to execute a contract. The big issue in a lot of these cases, particularly with the advancement of medicine and science, is so many folks now, of course, are living longer, and they are diagnosed with dementia or memory loss or some issues with lack of memory or capacity. But just because a person is suffering from those conditions, he or she can still make a will. They just have to meet the test. When, of course, a person comes into my office and we suspect any of those issues, we try to take extra care. But in any case, when we prepare a will, we generally ask those three questions. What do you own? Who are your family members? And what do you want to do with your property? And, we help them prepare the will. In my particular case from yesterday, the person had recently been diagnosed with dementia, and he disinherited his kids. But that's, of course, because his kids didn't provide for him, and his sisters provided for him. So the outcome of that case will be interesting. We will, after we took the deposition of the lawyer, we're going to proceed to take the deposition of the doctor, friends of the testator, and the personal banker to confirm that is in fact what the testator did. So if you have any questions concerning a will or this issue, please feel free to contact the Finklea Law Firm, and you can reach us by phone at 843-317-4900 or on the internet at FinkleyLaw.com, or you can email me at gfinkley@FinkleyLaw.com. Thank you very much.